Marbury versus Madison.
Well, this, of course, is the great case. It's the one that is fought to establish judicial review. It is important both because of the way that he did it, by coming out in a particular way which goes against what you would think he would be for. He uses a judicial technique that every judge has used ever since when they're doing something that is very difficult. They do it in a case where it's very hard for the people who oppose it to attack it because the case comes out their way. So that his ruling was a decision of establishing the courts as being independent and dominant where they have authority, but of course they don't have authority as to everything. And was he the creator of judicial review? No. That had existed in the States, it had been elsewhere, but no one puts it as powerfully or as dramatically. And it is really the foundation of all constitutional law now in every country in the world. Countries that didn't have it found the lack of it one reason why dictatorship came in. In Italy, a great Chief Justice of a Court of Cassation tried to strike down what were clearly unconstitutional decrees by Mussolini, but there was no tradition, so it failed. And it's the reason why after the war, Italy and most of those countries adopt a written constitution. And John Marshall is smiling over them because in a way he saw the opposite of what Learned Hand said, that a court will never be able to save a country that is heading towards dictatorship. He knew that it could.
The Burr trial.
Well, that's, there are various ways of looking at it. You can say he was not sympathetic to Jefferson, which he certainly was not, and therefore he was more sympathetic to Burr and so on. On the other hand, he was fundamentally a Federalist, and here's the guy who kills Hamilton, and that. I rather think that he understood that so much of the American Constitution was going to differ from English law in being more humane. That the American Constitution, with cruel and unusual punishment, wanted to avoid the horrible punishments of England. And I think in the Burr trial, what he wanted to do was to make treason be far narrower than it was under English law, because that's what this nation that he viewed as a nation, rather than as a lot of different nations, should be.
Dartmouth.
Well, that's the least interesting of the ones in a way, because there was nothing new in it. He had decided the same thing in a case called something Perry 10 years before. Fletcher versus Perry, something like that. So that Dartmouth College case stands for the sanctity of contracts and all that, but it's famous largely because of a lawyer in it and because of Dartmouth. It was not the case that established the principle. The principle is an important one. He was, in some interesting way, a libertarian. He was for government power, but there were limits, and the limits tended to be that which a modern economist would say are, I won't quite say Vienna School, but something of that sort. And there is a touch of that in John Marshall and in the Dartmouth College case. Interesting thing is how the contracts clause has almost disappeared in the 19th century, so that the courts that struck down workers' compensation as unconstitutional did it under all sorts of bizarre ways which couldn't work because they couldn't use the contracts clause. It had already faded out. That's one of the things of Marshall's that probably has not really survived the way he would have wanted it to.
McCulloch.
Well, McCulloch and Gibbons both stand together. I mean, they are the cases that say that this is one nation and that federal power cannot be viewed narrowly in what today people would call an odd sort of originalist, because I think originalism is okay, but you have to know what they meant. And Marshall's view of originalism, which comes out in these cases, is that this is one nation and is going to have to be able to govern as one nation. And so you get the necessary and proper clause as a way of saying there are any number of things which are not in the specific things which were enumerated, but which you have to be able to do. And it remains one of the most important clauses in the Constitution. And the other, the commerce power. And that these are the things that make this one country as to any number of things as against 13 small ones. Now here again, Marshall is interesting because he comes, I don't think we really realize how much the union that made America was a union of states that thought of themselves as being different. They joined together largely because of defense and the danger of other countries, the revolution, and because the economy demanded it. The West, you could not do it. But they had different values. And the whole conflict of people who do not view themselves then as one being put together is what Marshall was dealing with. Today we think of the difference as being slavery. That wasn't really the difference at the beginning. The North had slavery. Yes, there were strong differences. Difference was religion. The Puritans in New England couldn't stand the Anglicans in Virginia from a moral point of view. They'd killed each other just that many years before in England. And then you had the Quakers in Pennsylvania, the Catholics in Maryland, and God knows what's going on in Rhode Island. These were states, countries with very different values. Now, how do you put them together in that? And that was the challenge to Marshall. And he saw that if you put them together for reasons of the economy and say that is one thing, and then let on the other thing your immorality be accepted if I accept yours, which is why, as to religion, the states could continue to do what they wanted. Connecticut continued to have Congregationalism as the established religion until the 1830s. And there was nothing that Marshall or anybody did to avoid that, but that you emphasize the things which make you one to try to unite it. Again, look at Europe in a different way. After the war, you have this constitution in Italy, and Italy instead had always, even though they were separate countries, viewed itself as one language, one faith, one. And after the war, they set up separate provinces, the Constitutional Court does the opposite of Marshall and tries to defend the rights of these separate provinces to be different in the face of a tradition which says you're all the same, until, by the way, Sicily decides that it can decide what the law of Sicily is, and then the Constitutional Court comes down with the equivalent versus argument. That's the end of it.
Okay. The antelope.
Yeah, that's, of course, puzzling. Here you have this slavery case, and in which he both allows and doesn't allow, and it's been viewed in contrast with the Amistad not much later. It's hard to know. The interesting thing about the Amistad that many people have not seen is that the way the Amistad came out of saying, unless there is a specific law, slavery will not be recognized. Slavery, there is a natural law that is not there, and powers, nations don't have power unless they make laws with respect to it. That argument, which was made, John Quincy Adams made the argument, but the idea was given to him by Roger Sherman Baldwin, the local lawyer here, who was Roger Sherman's grandson. And it was Roger Sherman's argument as to why you didn't need a Bill of Rights. Because there wasn't power given, and therefore the nation couldn't do that. His grandson picks up that argument and makes it in the Amistad, and surprisingly wins. The antelope, that argument isn't made. And so Marshall seems to buy a kind of vague international law as allowing slavery in the face of what would have been a very strong argument the other way. I always think of that as one of his failures, as a case in which he didn't see the argument that had it been made, he would have come out a different way.
The Cherokee cases.
Well, those are the ones that interest me most for any particular reasons. One has to put that and the treatment of Native Americans, Indians, called, in context. It was one of the few things that Washington and Jefferson actually really agreed on. They tried to protect Native Americans from the pressure of the individual states. And basically they failed. Marshall, I think, was of that same view of the original founders, that there was something special here and that the states could not be trusted with respect to this. And he comes out in case after case at a time trying to protect by giving power to the federal government as against the states to protect the rights of the Native Americans, the Cherokees. John Quincy Adams writes to Judge Hopkinton, new judge whom he names in 1829, one of the last acts of my father's administration is to name John Marshall Chief Justice of the United States. One of the last acts of my administration is to name you Judge Hopkinton. If we were owed the thanks of the nation for nothing else, this would be enough because of all that John Marshall has done and all that I know you will do. I have this letter. Actually, it's a copy because Marshall sends Story to Philadelphia to get a copy of that letter because he needs it to reassure himself. He wants to know that John Quincy Adams thought he was a pretty good judge at a time when he is being, you'd think he was at the peak of his power, 1829, 1830. But he's writing these cases, and I think he knows that they're going to lose immediately. And I have a letter from Story to him. Here is the letter of which we spoke. It is in the hand of a daughter of Judge Hopkinton, a woman whom to know is to admire because she has so many of the qualities that we admire in her father. I give it to you for your comfort and for the comfort of your posterity when you shall be no more, so that your children will know that you were a good judge because John Quincy Adams said so, even though what you are doing now, this isn't in the letter, but I think this is in Marshall's mind, is going to be ignored. I don't know whether Jackson said, Marshall has made his decision, I let him enforce it or not. Doesn't matter. It's clear that Georgia is not going to enforce this, that all of these decisions are going to get ignored, that the Cherokees are going to be treated terribly. And yet Marshall had the law. And the reason the cases are particularly interesting to me is because when I clerked in 1958 for Hugo Black, there was a little case, 6-7-page opinion, called Williams v. Lee. And it's interesting first because Hugo Black, who had become this great believer in integration and was fighting desperately for integration, in what seemed like his old age, he was younger than I am now, realized that there were some people who didn't want integration, who wanted to be themselves. The Indians, the Native Americans. And he writes this opinion, which has become the key opinion in Native American law for the rights of Native Americans to set their agendas and their laws in the reservations. And he begins with Worcester v. Georgia and the Cherokee case. And he goes through how the cases were ignored, and then slowly how, because the law was right, they came to be accepted. And ends up in a kind of Hugo Black flourish with, that is the law we enforce today. John Marshall, you win. You win because you were right. And the case, as I say, has become a key case. At the time, we didn't think of it as being that important because Black really thought of it as being just Marshall doing it. And the amusing thing to me is that in those days, when you wrote an opinion, you sent the draft to the other chambers, and if they agreed, they just put their initials in the right-hand corner. Maybe that still happens, I don't know. And it came back from every chambers with initials immediately. The only one that didn't come right back was Frankfurt's. And of course, Black admired Frankfurter. They fought all the time, but they really respected each other in a fundamental sense. And so we were wondering what would happen. And then it came back 2 or 3 days later, and Black walks in my office waving this thing and says, Guy, he called me Guy because he couldn't pronounce Guido, said, Guy, here's what I told you. Felix, the smartest man in this court, smartest man in this court. And I look, and what Frankfurter had written was, I agree with every word, especially the essay on Brown versus Board of Education. Brown versus Board of Education never mentioned in the opinion the desegregation case. What was it? Frankfurter realized that at the height of the Southern resistance, Black was saying, you may ignore us, the way Georgia ignored Marshall, the way Jackson ignored Marshall. But if we are right in the law, we will win. And that was why he wrote that opinion as he did, to say John Marshall was right on the law with respect to Native Americans, and it may have taken 200 years, but that is the law we enforce today. And they may ignore us in ordering desegregation, but we are right on the law, and so we will win. And only Frankfurter saw that that was what Black was saying, and both of them were saying it. John Marshall, the greatest yet. You know, Jefferson is one of the most puzzling of people because one doesn't know if at the time of the making of the Constitution, when he isn't there, he agrees with his kid, Madison, who is the genius who puts it together, because, you know, the whole structure of the Constitution is more Madison than anything else. The judicial system is Madison. Any number of things are Madison, but fiercely Federalist in a way. And you wonder whether Jefferson agreed with that or not. I mean, the letters aren't clear. He then comes on, and in enormous opposition to this nationalizing thing, seems to be completely on the other side. And you wonder what's going on there, too, because you have Madison at that point kind of joining Jefferson in that and worrying about parties, supposedly, so long as it isn't their party, and that. And then he becomes president in a situation where Marshall was probably doing all he could to keep him from becoming president, so that they're not friends. And then as president, he starts doing some things which are very nationalist, very much the nation. Louisiana Purchase is, of course, the most dramatic, but any number of other things that Jefferson actually did were much more consistent with the original vision and the vision of Marshall as Chief Justice. So that while they were fighting at that time in particular cases and disagreeing, I have this feeling that ultimately Jefferson would have said of Marshall, would have come around to Marshall in the same way that Adams ultimately did before they both died on the same day. Aaron Burr was one of the most puzzling people. He was from here, from many ways from Connecticut. He was his closest friend was a grandson of Jonathan Edwards. He himself was very linked to the Jonathan Edwards. He went to the Litchfield Law School. He was a brilliant, and powerful person, extremely well connected and extremely ambitious. Was he a decent person? Who knows? His ambition kept getting more and more in his way, and though he should have been on the same side as Hamilton, because both were Federalists, he and Hamilton ultimately got into fights, and he shot him, killed him. That got him into any number of other problems, but I think the problem was not so much that, because Hamilton wasn't that well liked. He was feared, and so on. But it was that people came to think that Aaron Burr was, because of his intelligence, because of his connections and his power, a real danger. He goes off to Southwest, and it looks as though he wants to make a separate nation there. Now, remember, this is interesting. You have Marshall believing that the country has to be united, and because of the economy, and because of the West. So you would think that what Burr is accused of doing, which is of separating out the South, would be the thing that Marshall would be most opposed to, fundamentally. And Jefferson, maybe he is less of a Federalist, but not at this point. I mean, he is for the nation as a whole. And Jefferson goes after Burr, and they want him tried for treason. Well, treason, remember, at this time, you're thinking of treason. I don't mean that you had hanging, drawing, and quartering in the United States. Cruel and unusual punishment, but doesn't use the words, clearly had that in mind, because that's what happened to traitors, and not that long before in England. So that treason has connotations and moral notions that are enormous, and Jefferson is mad enough so that he uses that, wants that, against Aaron Burr, and despite his vision of the country, Marshall somehow says, no, you have to have much more evidence, much more specifics for treason. And so the treason trial fails, and Burr finally kind of disappears. Interestingly, as have so many people who really tried to undercut the nation in that sense. Only in the Civil War do you have it really exploding. But you have again and again people used to say in Europe on a white horse who would try to do that. That's Aaron Burr, a funny kind of Puritan on a white horse. Dartmouth College was this college that had been set up originally to serve the Indians. The founder was a Yalie who had gone up with a Bible and a drum and 5,000, how many gallons of New England rum is the story, to do this and set up this college, which was going to be there. I think of it less in terms of the specifics of that situation, but the not unusual attempt by states to control the educational institutions in their territory. The fight, you call it between town and gown, you call it the state, but the attempt to do what in most other countries is the case, to have education be governmental. And what in the United States instead, interestingly, that it has survived, has remained primarily private, with all the advantages and all the problems of that you see every day. And I think of New Hampshire as being just one example of that. And but I don't really know that that is what was moving Marshall in that case. As I say, I think it was much more the fact that he wanted to establish one of the reasons for the Constitution, the protection of contract, because what was going on in the Articles of Confederacy was that that contracts and agreements, and therefore the economy, was not able to function. So that in a sense, what this was doing was reminding us that the Constitution was put there to allow a national economy to work. and not let individuals. You could almost view it as the other side of what later became the unspoken commerce clause. You strike down attempts by states to burden interstate commerce. One of the long-term issues in the economy has always been, do you have a national economy? Do you have a national bank? Do you have a national currency? This fight between the left and the right of wanting to have much more local control of the economy, because too often the national control of the economy is one that is thought to serve industry and the big guys. The answer to that is that raises everybody. But you find this end of the 19th century, Jennings Bryan, Cross of Gold. Can you do gold? No, you want to do that. The same kind of notion, the populists not wanting a national bank that controls the currency. So Jackson's, even before the Indian thing, real fight, and those who viewed this as a nation that was there for economic and defense reasons say it has to be protected. Now, how do you find it? How do you find a way of doing it? Because there is nothing in the Constitution that specifically says you can do this. That's, for defense it says you can do an army. For this it can, but there's nothing in the Constitution that says you can do a bank. So are you stuck with what Sherman had said, if you don't have a specific power, you can't do it? Not that Sherman wouldn't have been directly for the bank, because he would have been. And Marshall, in the necessary and proper clause, finds the way. It says this is essential. Marshall is from Virginia. And here he is taking positions again and again that seem to be much more the positions that the North does. But Washington did too, in his very quiet way. And say Madison began that way. That's a side of Marshall, of course, what I don't know. But what made this Virginian be so economically a Northerner?
What did Daniel Webster argue in Dartmouth?
In the Dartmouth case,
yeah.
Well, he argued that this college, that had he gone there? I think so. That had to have independence, and he used that as a basis, as an emotional basis for the freedom of contract. That there was an agreement that it should have it, and it developed, and we love it because it has been that, and you can't take it away. But he was using that to make the broader argument. The notion of the commerce of the United States being what united us was, I think, probably the thing that those who wanted the Constitution as against the Articles, and those who saw it as, once defense had been won, the fundamental thing that made the nation, the one thing that you could not step back from, is, to me, fascinating, because today you get people who view themselves as being conservative, as being very clear on defense and going beyond any language in the Constitution on what the central government can do in defense things. After all, the president's power in these things is simply because he is called the head of the armies. A title doesn't really give power. The Chief Justice is Chief Justice of the United States. We don't think that the Chief Justice can go and make the law of Connecticut because of it. And yet, that is so, in a way that is consistent with the original vision of defense being a national issue. And yet they have problems seeing that with respect to the economy as being also a national issue. The slave trade and the Senate were the two things in the Constitution that could not be changed by constitutional amendments. The Constitution said that the end of the slave trade by a certain time, and not before, not after, that, and the makeup of the Senate were the two things in which the Constitution can't be changed. Kind of fascinating. What does that mean? I've always thought it meant that you needed two amendments. One to amend the Constitution to allow it to be changed, and then a second one to change it. But that's a dramatic, from a legal process point of view, because it makes it extraordinarily difficult. So the slave trade was no longer legal. Slave trade such could not be done. And yet, you had people of other countries doing this. And they're not in our control. So what happens when you get something of that sort going on? And I think that's what Marshall was facing in the Antelope. But the puzzling thing is in the Antelope that he finds authority in international law as to some of these slaves. And so slavery with respect to them is recognized. He doesn't find it as to a particular law of others because they weren't of those countries, and so comes out with what is a mixed decision, but as I say, one which not long after the Supreme Court, and it's the Supreme Court with Tawney and all sorts of people who were very much pro-slavery.
What did Marshall mean when he called in Cherokee Nation v. Georgia, he called them a domestic dependent nation? He called the Cherokees and other Indian tribes domestic dependent nation.
Well, the role of the position of these is complicated because Marshall did not want them to be independent nations, and he had ruled that first in the first of his. They are not independent nations who can do whatever they want. That would have been impossible to have in the center of this nation that he wanted to be unified a whole lot of totally independent nations. On the other hand, he doesn't want the states to be able to do with them whatever they want because the states will want to destroy them. They have no interest in protecting them at all. By creating this category which says you are independent but dependent on the federal government, he wants to set up a situation, which is what has ultimately happened, where limits on the independence of the Native Americans can be placed, but have to be placed by the nation as a whole, not by the local state that has a particular reason for taking that away. And you see that repeating itself again and again. You see it with Connecticut wanting originally to limit what some of the tribes here could do, and our court saying, no, you can't do it, you got to deal with them, unless the federal government, which represents the nation as a whole, can do it. You see it again and again all over the country. And it's actually saying, I think that's what Black was saying, one of the most brilliant kind of arrangements of saying there is something different from anything we had seen before, because of which our own sovereign states don't have power over them, and yet they are not so independent that the nation as a whole can't deal with it. Who was John Marshall? Well, he was a politician. He was part of that whole group who had the vision of the nation. He was a lawyer, and he clearly loved law. And I don't think he knew that initially. I mean, he started out, he went to the court after being Secretary of State. He'd done any number of other things. But while his predecessors, whom one tends to forget as Chief Justices of the United States, never thought that that was the way that they could develop most, Marshall found in being Chief Justice his real métier, that was what he was. So he was a lawyer, this guy from Virginia, who had been, one of a bunch of people who had put the country together, who was obviously very able, and so gets made a important cabinet officer by Adams, who wants a sovereigner who agrees with him on many of these things, but who finds that law is what he loves and uses that to make this country. So for me, people can say any number of other things about him. For me, who went to law school after thinking I was a mathematician, a historian, an economist, and so on, and found law, God, how wonderful. That's what Marshall is. I think his main objective as Chief Justice was to make this country one. Again, there were 13 separate countries that had come together for the sake of defeating England, and had stayed together because here was the whole West that could not be controlled by any part of this and would almost certainly fall to some foreign country. And the Constitution gets written to do that, to make this. So you have a person whose vision is out of many one. And that is what he wants to do as Chief Justice. And yet, there is a side of him that is sufficiently libertarian that there's always, yes, but you have to protect individual rights in some way. And you see that, so not treason, you see that with the contract clause, you see that as, but the main vision is to make this a united States. I guess it's hard to say. There are those, I think, who would say that somehow we would have come out the same way, that the logic of a written constitution would have required judicial review, that someone else could could have done it. One of Hugo Black's favorite phrases was attributed to Hamilton. We have a written constitution. The judiciary will be the protector of rights against any infringement of the rights of the people. Well, that says judicial review there, so that I think other people might have done it. The reason that it might have been different is that Marshall did it so well, that he was sufficiently a lawyer so that he did it in ways again and again, in case after case. He used all the game of law. And that's shaped the judiciary as much as anything else. It's what we've been copying ever since. So that we will write an opinion which comes out the opposite of the way the government wants, and yet the government wins that particular case. Did it myself in one. So the government can't appeal because they've won. And yet the law starts to get established in a way that makes sense. And so, it's more almost in technique. I think once you had a written constitution, and maybe I'm a child of that, so I can't see it in any other way. I cannot imagine that there would not have been judicial review, that there would not have been a nation with respect to commerce, even without Marshall. But how we would have gotten there, I think he'd be very surprised by some formalisms, about he might agree with the results, but I think he would find it very difficult to accept a notion that you look at words as text without context. You look at a situation that existed in 1789 and said, unless you have them doing something about that, but they specifically thought of, you can't deal with it. I think he would have thought that he would have understood why they were doing it, but I think he would have been quite puzzled by that. I mean, the one thing that you can say about Marshall is he was never brittle. He was always nuanced.
Which of Marshall's decisions would you most like to discuss with him?
I guess I've told you the Cherokee cases because I really would like to know if he was as troubled about the fact that he thought that they would not be carried out, and whether that was really bothering him, just on a human basis. I guess the other thing would be Gibbons, because I've often wondered about the Commerce Clause and what Marshall would really have done with situations where states violated interstate commerce, even though nothing was written. That whole other side of the Commerce Clause is something that has puzzled courts, has puzzled me about how much we should assume that, whether he would have thought of it in terms of, here is a situation where the Senate will always protect the state's right to interfere with the commerce, and therefore we have to have a court be able to do it, or so. I'd like to know more his broader view of that, both from a personal point of view, as I say, the Cherokee case.
Okay.
There are things that only a court can do to protect our nation. And courts must be there to do them. And that was in the end and in the beginning Marshall's vision. The Supreme Court was there to protect the nation in ways and as to things that nobody else could do. Problem is, what happens if you have some situations where the court sees something as fundamentally wrong but can't deal with it itself? Take the gerrymandering case. The minority comes down and says, what is happening is clearly unconstitutional. We don't know what to do about it, but we got to do it. Kind of hopeless. What would we do? The majority says it is clearly unconstitutional, and Scalia said it was, but since we don't know what to do about it, we'll let it be. My own view is that courts should dialogue, should talk to other lawmaking institutions, should use their strength and what they can do to make other lawmaking institutions do what they don't want to do. Suppose the court, in the gerrymandering case, had said, this is clearly unconstitutional. It is almost impossible for us to find the proper solution. Congress, you have 2 years to do it. If not, then we'll have to do it. But you have 2 years to do it. Now, that in any number of different situations is what some European courts have taken to doing, of saying, we know what we can do. We can't be the ones who makes the law ultimately in some things, but we can make sure that you do your job. Now, was Marshall seeing that? Maybe. You know, you can read some of his decisions as being dialogical, as being, this is what courts can do, and we will do it, and make you do the rest.
What decisions?
Well, I think, in a way, Marbury is a decision of that sort, which says, we can't do this, but you can. But you can't say for sure. This is the problem. And that's what you asked me. Are the courts that I'm not sure. And by the way, that's the conversation that I would most like to have with him, because my guess is he'd respond very quickly. He'd say, sure. But not always does dialogue work. That is, there are times when it is best for us to do it immediately. And I'll give you the example of that Hugo Black fought, even though he went along, all deliberate speed. That's dialogue. You know? And Black said, I went along because I wanted to be unanimous. But that was not something where you talk. That's a situation where you become the most traditional court. You say, these kids in this school today. And then let precedent and so on. And I think that the thing about Marshall is that he was flexible enough so that he would know that there were some situations where the best thing you can do is just that.